I'm John Nuechterlein. I'm going to begin with a disclaimer that I think will probably be unnecessary. I have a minimalist view of my role as a moderator here, and I don't intend to make controversial substantive statements, but in the event that I slip up, I am here speaking only for myself. I'm not speaking for anybody else at the agency for which I am the general counsel, which is the FTC. We have a wonderful panel here today. We're going to talk about standard essential patents and FRAND commitments, whether and how they are enforced, what institutions, what theories of law, whether private ordering is better than government intervention, and so forth. We're going to begin with an overview by Monica Barone of the issues that arise, and then we're going to turn it over in sequence to Michael Carrier of Rutgers, Richard Epstein of NYU, and Christopher Yu, whom you all know. And I'm going to try to, so that we can save enough time for discussion, I'm going to ask each presenter to try to limit his remarks to about 12 minutes. And I will give periodic notifications in the event that it looks like that may be violated. So Monica Barone of Qualcomm, you can go first.
Are you using slides, Monica?
Yes, I am.
Okay,
it's warmer in here now, so I can take my coat off. Okay.
This is not Rutgers.
It's interesting that people complained it was too warm.
No, it's too cold.
We delivered. We solved that problem, and hopefully we'll reach a happy equilibrium soon.
Well, you understand, by the way, that all functions are not linear.
Well, good afternoon, and we'll try to keep. I think this is going to be a very entertaining and insightful panel this afternoon. And if it doesn't get that way, I have a video that we can show at the end and wake everyone up. But with a show of hands, how many people are here have SEP or Standards Essential Patents background? How many of you have actually participated in a standard setting organization where you've been in a room with engineers and making contributions or being in a standard setting activity? One. Okay. How many of you are academics?
This is a term of insult in this one.
How many of you are in the industry? And how many of you would appreciate a little primer on standard essential patents? Yes, okay, thank you. All right, I wanted to find out our audience because I wanted to get right into it. And first I just want to tell you a little bit about Qualcomm, since Qualcomm's name has come up a couple of times today. Qualcomm was established in 1985, and CTIA was a standard, TDMA technology standard that was selected. And I won't go through the entire history, but needless to say, Qualcomm's business model has helped enable an entire mobile industry ecosystem through its technology investments and licensing of its technology. Not only is Qualcomm a licensor of its technology, it's also a implementer in standards organizations, and we'll go through what that means in a few minutes. Well, we wanted you to know, or I wanted you to know, that we basically use our business model to enable other industries or manufacturers and implementers and those interested in the mobile technology sector to be engaged and use our technology. And as a part of this, and through our licensing, we use our return on investment. And our licensing business model, I think we get about 30% of our revenues is based on the licensing revenues, where we enable other companies. We have over 250 CDMA licenses, and to date we're talking a lot about litigation, but I don't think we have any lawsuits, and that our negotiations have gone well, and those negotiations of course include a lot more than standards essential patents. We take a lot of this money since our inception in 1985. I believe it's $27.31 billion of cumulative R&D that we've pumped back into the industry. So we pump in R&D, then we get a return on that investment so we can continue to contribute and invest in the industry. So we think that business model has worked well and has enabled a number of other business models. Now, with respect to the standardization process, Qualcomm is engaged in over 100 standard-setting organizations around the globe. We have engineers that are participating, and what was your name who's actually involved in this? I think that's great. We'll have to talk afterwards. So with that, let me see if I can, I'm a technology lawyer, but not so good with the technology at times. Let's see if we can get to the next slide. Okay, so I'm going to give you a little overview of the presentation. I'm going to go through this pretty quickly because I really think the question and answer period is going to be very interesting. What I'm going to do is, so why is the licensing of standard essential patents a hot topic right now? I mean, it's a really hot topic, and I really have a great video I'd love to share with you, but I don't think I can on this. We're also going to go over the basics of standard essential patents, and what is a FRAND commitment? I have been doing this for a few years now, and I recall just 3 years ago, before some of the smartphone litigation, no one showed up for FRAND conferences. What's FRAND? What is this? I'd have 5 people in the room, and now I get hundreds of people in the room. And I think one of the things that I really appreciate about being here today is that we can have a dialogue. I think there have been some intimations to the effect that there is a lot of misunderstanding and confusion, and a lot of names being, or titles or things being thrown out there, where we really need to sit down and have a dialogue. So I'm hoping that we'll continue that after the conference today. Look at that phone. So why is the licensing of SEPs a hot topic? Well, number one, it's even the president has recognized the importance of standard essential patents. President Obama created the National Science and Technology Council Subcommittee on Standards, recognizing the importance of standards to the economy and to innovation. And so he elevated it a few years ago before we saw litigation pop up. So that was one indication. But another one is that there are thousands of standards, and before I got into the business, I had no idea what a standard was. I mean, you go, if you can't plug in your computer, or you can't interoperate, you can't talk to each other on your computers, that wouldn't work. That's what a standard is about. SEPs have also been in the news. Antitrust regulators in the U.S. and Europe have recently focused on SEP licensing, particularly in the ICT sector, citing a need for regulatory intervention. They talk about Samsung and Motorola. I don't want to go into all of these because I don't want to take up all the time, but you can look at these slides and there's other information I can get to you. But quite frankly, the FTC, DOJ, European regulators, and regulators around the globe are looking at these issues. And I'd like us to really step back. The brochure for today is Patent Reform, Theoretical Propositions and Factual Foundations. The book referred to before, a fractured fairy tale. There's patent truth. And so what I encourage us to do is try to get to the truth. What is really driving the dialogue today? Is there really an issue in standard setting organizations? Or is it just a few cases that are driving the debate and driving policy decisions right now? Indeed, one quote I'd like to share with you, others have stated another view. They've urged caution in intervening in this highly innovative sector. As Microsoft's chief patent counsel said, if you go back 100 years or 150 years to the telegraph and telephone and manufacturing technology, there was really significant debate at the time around the appropriateness of patent protection in those spaces, and courts and industry worked through it and moved forward. Eventually, this will normalize and sort itself out. So we don't believe any special measures are needed beyond good focus on applying the law correctly and understanding the law. And then there's another quote there too in terms of the encouragement to be careful and not to think that the sky is falling. I'm going to pass on this one. So I promised you the basics, so here we go. All right, so the development of industry standards often occurs within standard-setting organizations, and that's ETSI, IEEE, ATIS, TIA. There are hundreds of them around the globe, and like I said, we're engaged in over 100 ourselves. They usually have a ton of companies. Academics can show up. Anyone who is interested in where technology is going can come. It's usually open, and particularly in the United States, unlike China and other places, it's a voluntary process. It's called voluntary consensus-based standards, so where the companies get together and they try to come up with the best technological solutions. They work together. They can submit their technology as a proposed contribution, but where I think what we really want to focus on today is not only are you there to contribute your technology, but there are policies and bylaws and rules that each participant has to follow. The SSOs typically have an IPR policy, and members are required to agree to it when they join the group. So if you are a firm that's representing a company, you want to be sure that you review the IPR policy to make sure that there isn't anything in there that may have a negative impact on your company. I know I've reviewed hundreds of those things before. Once a standard is adopted, typically anyone, not just the members, can use the standard and make a product that implements the standard. Common elements of the IPR policy, and this is where we're going to hear about the disputes today, are the disclosure and the licensing portions. Patent holders that are involved in a technology standard and they believe that they have a standard or essential patent that could or potentially read on the standard, they have to disclose that. And most IPR policies also, once you disclose that, you have to make a licensing declaration and tell the community if you intend to license, and if so, on what terms. And that would be, in most cases, FRAND, fair, reasonable, and non-discriminatory. FRAND is in Europe, RAND is in the United States. So you're making a commitment to the standards body that you're going to license, and if you don't make that commitment, you are probably going to be shut out, and your technology will not be included in the standard. So the two ETSI IPR policies is one example, and the two fundamental objectives, going back to my description of Qualcomm, is fair compensation for those who contribute their technology to the standard and access to essential patents for those who wish to use the standards. A FRAND commitment is voluntary and not mandatory. And like I said, Qualcomm both implements standards and also contributes technology into standards organizations. Okay, if my time is up, I may need to get into a discussion of FRAND and what it really means. But a FRAND commitment is a contractual commitment that is often requested by SSOs for members that participate in standard setting process. Implementers that are not members of the SSO may be a third-party beneficiary. The terms of the contractual commitment depend on the IPR policy of all the SSOs. Again, as I said, you need to look carefully at the SSO IPR policy because each SSO may have different terms and conditions, so you want to be sure you read it carefully. A FRAND commitment. Okay, what a FRAND commitment? It's a contract. It depends on the SSO IPR policy. And here's an example of the ETSI IPR policy. It's an obligation to offer a license on FRAND terms to anyone who wants to make equipment compliant with the standard subject to reciprocity. This is intentionally flexible but binding, a concept that allows for license terms to be determined through bilateral negotiations. And on that note, most SSO policies say that the contract or the licensing negotiations between the parties take place outside of the SDO because you're there for technological solutions. You're not there to come up with licensing terms. And then a FRAND commitment is not a creation of statute, economic theory, or public policy. It's an agreement that SEPs or an agreement that SEPs are less valuable than other patents, or a waiver of the patent owner's rights or remedies. And then I'm not aware of any SSO policy that specifically defines RAND terms. And like I said before, that term is flexible to give the parties flexibility in their negotiations, because many times the contract between the companies involve a lot more than SEPs, and many more contract terms other than standard essential patents. And that's my quick overview, and I'll be glad to answer any questions after this or during the conversation. Thank you.
Okay, thanks, Monica. And now we'll hear from Michael.
I'd like to thank Christopher for putting this together, Penn for hosting us, and in a sentence I don't usually say, I'd like to thank the House of Representatives. The House of Representatives made this conference even more relevant than it was going to be to begin with. When we talk about patent reform and we think about what we've done this morning, what we're going to do the rest of the day, we in this room know that this is very important stuff that's very timely, but it is hard to engineer a conference, and I congratulate Christopher on engineering the timing of having the House act yesterday to have them literally deal with patent reform as we're talking about it today. And so the topic of today's panel has not gotten as much attention, but the topic of standard essential patents is one that over the last year or so has really burst into the news from the president on down. And so what I will do is build on Monica's introduction, first by giving a little more detail on the context of standard setting organizations, second talking about the question of injunctive relief, third looking at the role of antitrust law, and fourth closing with some miscellaneous issues. First, as Monica talked about, we are talking about standard setting organizations that set standards which are common specifications that allow all of us to plug in our laptops and not worry about wireless connection. What we're talking about in particular here are standard essential patents, which are patents that are essential to the use of a technology. Now, what does that mean? It depends on the standards organization. Sometimes it is technically essential, sometimes it is commercially essential, but in all cases it is declared essential. In other words, it is the patentee that declares that their patent is essential, and typically that is not adjudicated by the standards organization. So the academic studies that have looked at it have found that only 21 to 40% of patents that are declared essential really are essential, and so that's one other point to keep in mind. The general concern with the standard setting process is the difference between ex ante and ex post market power. Ex ante, before the standard is selected, the standards organization can select from a range of patented technologies. At the time, there isn't necessarily market power held by any particular patentee. After the standard has been selected, however, and the patent is incorporated into the standard, the concern is that that patentee has market power. The ability to hold up the standard, to refuse to license the patent, to charge an excessive royalty. And that's why we see these rules that standards organizations have adopted. Disclosure rules were all the rage a decade ago. We had cases in which, for example, a company would refuse to disclose patents, and so that was something that the standards organization needs to know, that if it is adopting a particular standard, that there is a patent involved. And now we're talking a lot about these RAND issues. Again, RAND in the US, FRAND in Europe, no real difference, because there the promise is that the entity will reasonably license their patent. Fine, it's going to be incorporated into the standard, but at least it's going to be a reasonable royalty. That's easy to say in theory, but as today's panel will see, it's really hard to do in practice. And so one question is, are you able to get an injunction after you make a FRAND promise? And there really are two possible answers here. One is no, the other is sometimes. If you look at the argument for no, it's basically an argument based on fairness. You made this FRAND promise to the standards organization. That's why you were selected, and so it's not fair to go out and get an injunction. So for that, you look at Judge Posner in the Apple Motorola case, saying that when you make this FRAND promise, you're assuring that a royalty is adequate compensation, so therefore you're not able to get an injunction. Similarly, you look at Judge Robart in the Microsoft Motorola case in Washington, where he said that Motorola was not able to show irreparable injury because of this FRAND promise. So again, it's an argument based on fairness. You make this FRAND promise, therefore it's not fair for you to go out and get an injunction. A more nuanced perspective is that sometimes injunctions are appropriate. So for example, you look at the FTC's order in Google, you look at the DOJ PTO statement in January of 2013 to the ITC, you look at the USTR statement for the exclusion order on Apple, and all of these places are saying in certain cases an injunction is appropriate. So for example, if you have an unwilling licensee that is clearly unwilling because it's refusing to pay a royalty that was adjudicated by either a court or an arbitrator, in that case, or where the licensee is refusing to negotiate, an injunction is appropriate. You also look at someone who is not subject to the jurisdiction of a U.S. court, perhaps an injunction is appropriate there. So the answer here is that injunctions sometimes are appropriate. Outside those clear cases, it becomes a little more difficult. So for example, one question is, when do we have an unwilling licensee? A licensee that is not willing to pay for the reasonable royalty that is charged by the patent owner. That's hard, and you have two different sides to a negotiation. It is tough to figure out who exactly is right there. You also take a step back, a step out of law into negotiations, and you ask, what is the role of injunctive relief here? So the standards implementer is going to say, patentee, you shouldn't have an injunction in the first place. Again, you promised to reasonably license this, so if you hold an injunction over our head, then that's going to distort the negotiation process and lead to a rate that's higher than it otherwise should be. On the other hand, the standard essential patent owner is going to say, this is the only leverage that I have. If I'm not able to threaten to hold and to have an injunction against the licensor, then they're just going to sit on their hands. They're going to continue to infringe. They'll wait until they're sued, and only at the end of litigation will they have to pay a FRAND rate anyway. This is the only leverage that I have. And so again, we're at a conference talking about facts, so I'm sure the panel will talk about which of these really is happening. Is hold-up a concern? Is reverse hold-up a concern? These are some of the empirical questions we should be asking. The third point deals with antitrust. And so when you talk about a promise that's made in a standards organization, we have the concern that this collection of competitors is getting together and that there could be harm to the competitive process. You go back a couple decades, the Federal Trade Commission has been focused on this issue. So they started with the cases that dealt with manipulation, in which one side is manipulating the standard to hurt the other. You look at the deception cases, and then you look at the statements that come out of the FTC in terms of the integrity of the standard setting process, making sure that this competitive process works. And then you look at what has been done, not only in the EC, as Monica talked about, but also in the DOJ and signing off on the Nortel and Motorola deals, and then with the FTC itself and looking at cases like Bosch and Google. What's going on here is that the antitrust agencies are figuring out what to do. When, if at all, is it an antitrust violation for a company that's made a FRAND promise in a standards organization to refuse to license it according to those terms? With 5 minutes left, let me just get to my last point, which are the many miscellaneous issues that arise here. So one involves the FRAND rate. Fine, so everyone agrees that there's a FRAND rate. What exactly does that mean? So we have the benefit of two cases, one from Judge Robart, one from Judge Holderman in the Innovatio case, where they're trying to figure out exactly what a FRAND rate is. Basically, they take the Georgia Pacific factors, they tweak them, and they say that big picture, what we're trying to do is look at the importance of the patent to the standard, look at the importance of that to the product, and look for comparable licenses. A patent pool perhaps is not a comparable license. Maybe it's a little too low. We'll look for other licenses that are out there, maybe not the subject of settlement. We're trying to figure out ballpark figures as to how to know what a RAND rate is. Even beyond RAND rate, there are numerous questions. Does the initial offer have to be on RAND terms? What about non-SEPs? Is an implementer forced to take non-SEPs along with its standard essential patent? What about reciprocity? Is the standard essential patent owner entitled to get the standard essential patents from the licensee as well? Royalty stacking is another concern, that you stack up all of these royalties on top of each other, and all of a sudden it becomes very high. This is something that Judge Robart and Holderman focused on. In contrast, in the Texas case, Erickson v. Intel, the court said that this is just speculative, so royalty stacking is not going to be looked at in that case. What about the transfer? Is a FRAND obligation something that runs with the transfer, or can it be avoided when someone passes it to someone else? It would seem like it would stick stick with the transfer. Otherwise, you would just transfer and get rid of these obligations, but that's another question. Is there a role for arbitration in the case in which it's unclear what RAND means? And finally, what is the role of comity? So what happens when we have these global disputes going on at the same time? Again, Microsoft Motorola being litigated at the same time in Germany as well as the Western District of Washington, and Washington said, Germany, hold on, at least you're not able to get an injunction there because it does not offend comity for Washington to decide it first. This is an issue of state law. You went to Germany second. Big picture, there are lots of issues going on in terms of the global arena. So at the end of the day, we do have this panel on standard essential patents. There's a lot of attention on it, and antitrust comes to this task with the tools to deal with standard essential patents. But taking the step back, you can question how important is this question in general? What about other types of patents? Do design patents perhaps have even more power because they're not subject to this constraint? What about these patents that involve pledges outside the standard setting context? How much focus should we pay to those? And so in short, there are a lot of issues that I'm sure the panel will continue to talk about, and I thank you for your attention.
Thank you, Michael. Richard Epstein is next.
Thank you. What I want to do is to praise the two previous speakers for their reasonable and balanced presentation, and to assure you that I will not follow in their footsteps. This is an issue, I think, of extreme importance. I think in general, in particular, that the FTC approach on this, which was announced during the past summer or whatever it was, represents a serious misunderstanding about the way in which this area ought to be put together and ought to be emphatically and decisively rejected. This is a moderate position. And I sent around a paper that I co-authored with David Kapos, and I did a previous paper with Scott Keefe and with Dan Spolger on this issue. And in order to put the point in perspective, I think we have to do something with respect to intellectual property and licenses, which we often do not do. What happens is we treat intellectual property as though it's a discipline unto itself, and we don't set it back against the general principles with respect to property law. And we treat licensing as though it's a domain in and of itself, and we never set it back against general kinds of contractual provisions. And it seems to me that the correct way in which you want to get to the particular is to start with the general, to figure out the way in which you want to mix and match liability rules and remedies to deal with this full subject. There is no time here, obviously, to go through all of the endless variations on the point, but let me start this with the title of the paper, which is the question of, do we like the theory of efficient breach as part of the law of contract? And it's a very snazzy theory. It debates back to the 1970s, and it says we all love expectation damages because what it allows you to do is to secure Pareto improvements. The way in which it does that is we leave the individual plaintiff who sues indifferent by giving him money that puts him back into the pre-breach situation, and then the defendant gains all the surplus unilaterally from producing the particular change in question. So one guy is better off and the other guy is not worse off. The theory, I think, is completely wrong, and let me just mention some of the particular problems that are associated with its application in the general case. The first of these things is it represents on a very false view of the way in which the theory of expectation damages works. There are all sorts of refinements in the doctrine, and what these typically end up saying is that some large class of damages, in fact, are going to be excluded from the calculation. In fact, if you go back and the mother of all damages cases, which is Hadley and Baxendale, what you discover is that the expectation measure of damages is lost profits, and that's the measure which is explicitly rejected in the case. If you go on and do some of the rest of the work, difficulties of estimation in many cases means that you have to give systematically low evidence or bias estimates on the question of damages so that it turns out that you're not going to get that kind of parity. Even if you got it, you have to factor into account litigation expenses, which can be enormous, so that what happens is if you follow the model which allows people to make conscious and deliberate breaches, what you do is you completely destabilize the property system with respect to the parties in question, so that the appropriate rule in virtually all of these cases is to reserve damages for those situations in which the breach is inevitable or accidental, and to essentially have very sharp sanctions against people who convert unilaterally contractual obligation in an option to essentially liquidate that obligation at an indefinite price. We also know that if this is an efficient theory, there would be somebody in the history of Western civilization who would have drafted a contract which had actually embodied it. And every time you look at the various kinds of options that are included in various sorts of contracts, I think I can say in the entire history of Western civilization, there has never been a contract which says we give you the option to terminate on payment of damages as determined by the theory of efficient breach. What happens is people always liquidate the particular obligation, give you precise numbers as to what it is, so that the option becomes more or less coherent. There are conditions on when it could be exercised or not. It turns out, for example, if you look back at Lisa Bernstein's literature on how it is that the doctrine of efficient breach is interacted with general trade association norms, the party which engages in the strategy of efficient breach and says, hey, I managed to do this deliberately because I got more money by selling this thing out to somebody else, is expelled from the trade association. So what happens is if this is the way in which the system starts to work as a matter of general situations, then in effect what we certainly want to do is to make sure that we don't take a standard of this particular sort and make it essentially the gold standard with respect to the way in which we think about patent obligations and their potential breaches. But if you then start to look at the way in which this thing goes, the downward spiral begins with essentially the eBay case, where the Supreme Court gets wrong the common law rules with respect to equity, makes them much more discretionary than in fact they were, carries it over into this particular area, and makes it appear as though you have all sorts of discretion. I think the decisions that have come in the last 5 or 6 years have tended to cut back on this, that the number of cases in which you are pushed to these kinds of alternatives are relatively small. I don't think that we want to spend our time in an intelligent discourse litigating the public interest benefits of either breaching or not breaching under all these various circumstances. So what happens is you then look at this background and you start to see how it is it works together with standard setting organizations. And what we know about these organizations is that they are engaged in dangerous business. They are trying to figure out how it is that you coordinate multiple players so as to be able to form interoperative standards that depend upon contributions from multiple players, and then they're going to send these things out into the rest of the world where there is no question that there is a serious risk of monopoly power, which is why it is that you have the FRAND obligation. The question is how you deal with a FRAND obligation, and it depends very much on the kind of business that you're in. If you're a public utility, you've got all sorts of powers, and in fact we impose reasonable rates on you using a kind of FRAND formula. But this is a relatively static industry with very few classes of customers, pretty constant technologies, huge rate bases. And, we did this in the 19th century, and generally speaking, they did it pretty well. In fact, I think I could say almost categorically that the level of economic sophistication that the 19th and early 20th century judges brought to rate-making procedures are greater than that we see today in many of these same areas. They just took it much more seriously, and in effect, the property rights issues actually mattered to them, which is why they call this confiscatory takings. When you get into the modern setting, it turns out that using that kind of institutional framework strikes me as being completely misguided. If you take the number of patents that you're going to have to worry about in standard setting organizations, and you worry about, for example, the portfolio of Qualcomm, with whom I work, by the way, I should make that very clear, what you discover is there in about 100 some odd organizations, they have thousands of disputes. The number of breakdowns that take place given the voluntary framework in which you surround the particular organizational decisions seems to be close to zero. So what you're doing is you're trying to take a standard that's being imposed from without, which has never been observed or used by anybody inside the industry. And the great danger of the FTC and the critics is in fact reflected by the distribution of knowledge in this room. Most of us don't work in this area. I said the same thing earlier before the break about changing the rules on winners and loser pays when you don't know how the whole system is together. And I regard the FTC's rules as essentially throwing a huge monkey wrench when it announces that the appropriate standard is the incremental value of the patented technology over alternatives available at the time that the standard was defined. That is the most dangerous standard that you could possibly use for these situations. Let me just mention a couple of the problems before I sit down. First of all, if you do it at the time that the standard was defined and fix it that way, it suggests that there's no price variability, as it turns out that the value of the standard increases over time, as sometimes happens. Why that should be the case, I do not know. Secondly, why anything should be capped when you're trying to figure out how to determine royalties is again a mystery, because if you cap anything, it means that the necessary bias is going to be in favor of too low rather than too high, because you've got an upper bound on the system and you have no lower bound. The third point about this particular standard is if in fact you give it at that particular rate, there is now no incentive on the part of the outsider to conform to the standard if they can take the technology and use it, and they are going, in the event that a breach occurs, to only have to pay this particular amount. Why take the chance of signing up voluntarily if you can do better off by virtue of breach? One of the great mistakes that the FTC report makes, and is commonly made in this area, is that you assume that the design of damage remedies for a breach of contract is only designed to handle the question of damages after the breach occurs. This is devastating error. The key feature of an intelligent set of damage remedies is to reduce the probability of there being a breach in the first place, so that you don't have to figure out how to go through these calculations. Now, is it something which is easy to do? Well, there have been a couple of cases that have been referred to by the worthy Professor Carrier, and I think he accurately described them. There's a recent one that just came out yesterday that I saw called Erickson against D-Link, where in fact the plaintiff did win this one fairly cleanly on very strong expert testimony, I might add, looking at the particular record. And in fact, you start to see the kinds of issues that you have to do in order to determine this stuff. It's very, very difficult, even when you get it right. And so the thought that you want to adopt a rule which is going to create an increased probability of litigation by giving deliberate options to default seems to me to essentially create a difficulty that you do not want. But we are always told that there's a holdout problem. And so there is, but there are two answers to that as well. One, the whole way that this system is designed, in the way in which you separate the technical people from the legal people, is in fact an institutional response by all of these firms who know that in the long run, that if they sabotage particular standards for their own private benefit, that the industry is going to falter and they'll go down with it, means that in the ex-ante perspective, there are really strong institutional constraints that are going on. The second problem, of course, that we have, and it crops up in these cases and will only become more conspicuous if the FTC rules are adopted, is the issue that was alluded to of the reverse holder. That is, there's nothing which says that when you're talking about scoundrels, that they're all on the side of the plaintiffs or all on the side of the defendants. In fact, the great debate over the recent Goodlotty litigation or other legislation is that you don't know who the bad guys are in large number of cases. And it's instructive when after the statute is, or the bill is published, 40 organizations from all walks of life come forward and say, you know, you have no idea how this is going to influence our business, and it's all going to be for the worse. Now, I don't know whether they're right or whether they're wrong. I suspect that on average they're probably going to be right. And the last point I want to make is one that's related to the above points. How much more, John? 1 second. 1 minute. Okay. And it's simply that when you look at the way in which these things work, it's a mistake to take each case in isolation. What you're always worried about, if there's non-performance at one level, it will cascade and lead to non-performances up and down the chain, and so that it will metastasize and you'll get more and more of these disputes. In business, we talk about just-in-time inventory. Everybody talks about keeping on the production path. Nobody wants to talk about damages. Everybody wants to talk about performance. And what people do with respect to tangible products, they should do with respect to intellectual products as well. Thank you.
All right, thanks. And last we have Chris Yu.
As multiple people have said, we owe a debt of thanks to the House of Representatives for making this particular conference more relevant than we would otherwise think. I've been told by my colleague Gus Hurwitz that we also owe a debt of thanks to the Supreme Court. Earlier today, they granted certiorari in Alice Corp versus CSLS Bank, in which the court will determine the patentability of software. And if there were not two events that could make this conference more timely, it's hard to imagine what they would be. Yes.
Are these guys crazy?
Whether the Supreme Court is crazy or not, I leave to is a rhetorical question to the audience. So one of the interesting things that is fascinating to me about this is the lack of clarity that's around FRAND. You get standard setting organizations that get patent holders to agree to terms that are never defined by the standard setting organization. And in fact, there's it's a lack of theory. Now, all of you who are law firm partners understand we do this all the time. And people who seek tenure, I confess, I never actually read the partnership standard or the tenure standard before I joined. We have these weird things, but there's a tremendous amount of lack of clarity, no guidance from the SSOs. One case is actually litigated into judgment. That would be the Motorola, Microsoft versus Motorola case mentioned earlier. And in fact, what I find is that this is an area where we need some thinking and there's not a great deal of guidance. So this is my longer term apology for the fact that I'm about to present a theoretical, very pointy-headed academic paper that potentially explains gives one way of thinking about how we might be able to shed some additional light on this. Did you take the presenter, Richard?
What?
Oh, it's right there. Okay.
Oh, I didn't. I took the pen.
All right, thank you. Pen you can take. So what I would say is one of the things that's interesting to me in this space is that the standard that's traditionally used in this space is exactly one that Richard said, criticized, and I don't mean to criticize it in the same way, but it's to try to mimic the bargaining power that the patent holder would have had if the standard had never been adopted. Look at that position and try to replicate it. But what's interesting to me, and it's also implemented through uniform royalty rates, based on how much the final revenue is classed and is supposedly uniform across all the people who license the patent, hence a particular vision of how we think about the word non-discriminatory. Now what's striking to me is that from a policy standpoint, it is not a very satisfactory one from the way an economist analyzes it. It would look at actually trying to equalize the bargaining power that existed before, assumes the existing distribution of entitlement was itself the optimal one. And we have a whole debate about whether that's in fact true, but it also presumes that that pre-existing distribution was not in fact changed by the standard setting process at all. And that in fact what we need is a welfare metric for deciding what the proper way to dividing these the different aspects are. And what you could look at is a different form to look to public good economics. It's often said, without really understanding it, that intellectual property is a public good. And in fact, there is what's often called the marginal cost pricing problem. We know it's well established that in high fixed cost industries, some form of price discrimination is a necessary condition for actually allocating and creating works through private markets. What's fascinating to me, and this has been bothering me for a great deal, is that many people think that is the public goods pricing problem. If you read Paul Samuelson's work on public goods, he says there is another problem that is the real public goods problem that remains even if you solve this pricing problem. I took this as a great puzzle several years ago in a copyright context, and I realized in a conference I presented earlier this year that it has an application to the FRAND debate. And so I'd like to talk to you about that today. So what is the difference between public goods and private goods? And an unhappy computer.
You just have to talk.
All right. The key difference, the classic private good. Sorry, I'm screwing up. Is that in fact it can be illustrated by a simple two-person economy. We have two people, we'll call them Allison and Brendan, and they each want to buy, say, two different kinds of goods, apples and oranges, and we think about, they allocate the purchases through different things. And the question is, you ask, what is the demand for apples? Well, at this price, at a given price, you say, how many apples does Allison want? How many apples does Brendan want? And you sum up the quantities, and that becomes the demand at that price. You vary the prices, you get an entire demand schedule, and the additional production is by producing more apples. And in this world, you get a very, very interesting outcome. So to take this, you have in this example, the first is, if you will, Allison's demand for apples. She demands at price A, she demands AA. At price A, Brendan demands AB. And you simply, at that same price, add the two quantities AA and AB to get the total market demand at that price. We put it by a supply curve, we get an equilibrium, fairly normal. Now what's striking about this is all of them pay the same price and signal the difference in their preferences by consuming different quantities. And in fact, we have, in this case, and what I'll jump to it is that, in fact, it is what we call an incentive-compatible mechanism, which is, I have no reason to lie about how much I like apples. Oh, I know, I'll lie. I'll consume fewer apples. Well, what that means is that I have a marginal benefit for more apples that exceeds the price, and I'm only hurting myself. I have no incentive to do that. It's what we call Pareto optimal as well for a variety of reasons, and if you're really interested, I left those slides off. But this is the traditional way that we learn in Economics 101. That's our baseline. Now, what happens if people consume, if it's a public good, the assumption is that whatever you make, everyone consumes the entire industry output. The example given in a textbook that I like is, let's say that we have a fireworks display in the sky. However big I make this or small I make it, all of us are going to see the same fireworks display. We cannot vary the quantity we consume. Now, we can vary the number of rockets in the fireworks display. That's how we vary quantity in the space, but whatever we set at, everyone gets exactly the same display. Put in the context of patents, we can put more R&D in a product, we can put less R&D in a product, get more features out of it, but whatever we do, once the technology is developed, that's it. Everyone gets the same thing. Now here, it's different. Before I said you set a price and see what quantity they consume. That contradicts what I just said, which is what Arrow called the indivisibility problem. You consume the same quantity, whatever we set it at. The only way we can signal the intensity of our preferences is by paying different prices. We have variable prices, variable intensities, and we have to set a demand curve in a different way. And so what you end up looking at is you set a price at the top. So at this quantity, which I'm calling I, how much would Allison pay for it? At the same quantity, how much would Brendan pay for it? And then you sum them vertically instead of horizontally and say, at this quantity, the total demand should be Allison's price plus Brendan's price. In other words, we look at the sum of their valuations vertically and to try to understand what that means. And that's how we put a supply curve against it, and we get an equilibrium. Now, to linger on this, remember in the private goods case, everyone paid the same price and consumed different quantities. Here, everyone consumes the same quantity and pays different prices. And that is the essence of the Samuelson condition and public good economics, is that is the necessary condition you have to have in order to create optimality. Now, there's a couple other things about this which are very interesting. So the first one I just said, they pay the same difference on how they do it, but the question then becomes is, what is the efficient outcome? Well, the efficient outcome would be, is you want to produce more of a good whenever the benefits created of increasing production exceed the costs of doing so. And so when you're creating more apples, you create more apples, and then the costs of them start to trail up, and the benefits start to trail down, and you end up at a point where the marginal benefit each of them receives is exactly equal, because that's when they stop producing apples at 50 cents. If I valued it at that much, I keep increasing my possibility. We all derive the same value from it, and it equals marginal cost. That's the equilibrium, and it's also optimal. In a public goods context, you want to keep increasing the size of the good until it equals the sum of the marginal benefits of Allison and Brendan. If they would actually continue to value more, you keep increasing the size of the good, but you ask, how much would Allison benefit if I made this good even better? How much would Brendan? And the additional value, that's the optimal. You have to set it to the sum of their valuations, not to their individual valuations. Which means, has several interesting implications that go through this. The number one is, it changes what we think of as the natural. It makes price another demonstration that on the demand side, that price discrimination is a natural feature of intellectual property markets because they're public goods. And that in fact, charging uniform prices will lead to a systematic underfunding of the goods in ways that are going to be detrimental from a standpoint of economics. The other thing that's really weird about this is that unlike private goods where it's incentive compatible, you can spite yourself by you have no incentive to misrepresent how much you like the goods. Here, I'm going to get the same thing as everyone else. But you have to tell me, how much would you incrementally value this good? One, you cannot find out what that is. That's my personal valuation. I have no incentive to reveal it. Second, because it's a public good, I have the incentive to lie and to try to get all the rest of you to contribute to the fixed cost of production. And that, in fact, you end up in a strategic game where people can try to lay the fixed costs on other people. And because you only depend on the patent being funded by the marginal benefit of everyone, you are still retaining some degree of surplus. If I can get you to cannibalize some of the surplus you get to fund the IP instead of using my marginal benefit, I actually have an incentive to do this hold-up game to try to lay my costs on everyone else. So this actually gives us a welfare metric for understanding how big the problem is, but also tells us that there's an incentive compatibility problem that's going to lead to a systematic market failure, and it has a series of implications which I think affect this space. So what would I think those implications are going to be? One, I said already, non-uniform pricing, as in any public goods, is a natural incident of the production in this space. Two, because consumers retain surplus, and because the optimal condition is based on your incremental surplus, each of them have, some people say in a price discriminatory world, consumers are left with no surplus. That is false under this analysis. We only have to charge each individual consumer the incremental benefit of a slightly bigger good or a slightly more improved good. That still leaves rooms for consumers to benefit, and that in fact this form of price discrimination does not necessarily always hurt consumers. Now that's all the good news. The bad news is the informational requirements for any form of price discrimination are extremely high and very, very institutionally hard to do. Second, because you have some retained surplus by the consumers, and because they can't be counted on to reveal this, they can play games against each other to try to get other people to fund the good instead of them. Don't just charge my incremental benefit, charge me less, take it out of what would have been their consumer surplus, we still get the good, and you end up with an unstable situation. There's also something that we forget. The whole reason we have a patent system is because patent holders are vulnerable to sunk cost opportunism. Once you create the R&D, those sunk costs are out the door. If you're in a truly competitive environment, you're beaten down to marginal cost. So there are opposing opportunisms. We also have a moral hazard problem. In a world of uncertainty, any investments are I even set my own timer. So they're all contingent. They're risky. You're looking for a few hits to carry out everything else, but in a world of ex post opportunism, everyone else in the FRAND license can wait and see what the actual results are and pick the winners and share the winners and not leave you with the losers. But the last thing I'll say is that I think is a pretty interesting thing is that in fact standards bundle patents, and I won't go into this at great length because I'm running out of time. There is elaborate literature about how bundling goods with different demands together can actually make it more efficient to provision them. This has some serious implications for the whole thing about our basic approach to doing this, which is taking it woodenly on a percentage of revenue on a uniform basis across all the different people who want to license the patent. What it suggests is that we should take a more nuanced view of this that would tolerate different classes of users. The real license should be based on the incremental value different classes of users derive from using it, but at the same time being sensitive to the problems of potential of hold-up and other strategic activity that may actually hurt this environment.
Thank you. Thank you, Christopher. I'm going to open up the floor for questions, but to get the discussion started, I'm going to read a quote, and then I'm going to ask a couple questions. So listen carefully. Here's the quote. The proper method of computing a FRAND royalty starts with what the cost to the licensee would have been of obtaining, just before the patented invention was declared essential to compliance with the industry standard, a license for the function performed by the patent. The cost would be a measure of the value of the patent qua patent. But once a patent becomes essential to a standard, the patentee's bargaining power surges because a prospective licensee has no alternative to licensing the patent. He is at the patentee's mercy. The purpose of the FRAND requirements is to confine the patentee's royalty demand to the value conferred by the patent itself as distinct from the additional value, the hold-up value, conferred by the patents being designated as standard essential. Two questions for Richard. One is, can you name the author of that passage?
I guess I wrote something like that.
And the second, what is your reaction to it?
Well, my reaction to it is essentially that that's why we have FRAND obligations, because it turns out that there is a genuine holdout problem. But also the reaction to it is how you determine what the optimal price is on this thing has to take into account the full range of variables both before and after formation. And what's wrong with it as a complete statement of the situation is that the dynamic elements are not taken into account in that passage and are taken into account in this particular paper.
Do you know who wrote that?
Who wrote that? Did I?
No, Richard Posner.
Oh,
Yeah.
Posner wrote it. Well, then I could attack it much more vehemently. I'll tell you why I would attack it. I mean, I thought most of the things that Dick writes, there's always a modicum of sense in it. But again, it's the passage, as I said to you. It hits the reason why we have this organization and limitations, but it doesn't handle any of the interactive effects. It doesn't explain to you how it is you're going to keep people inside the system. It doesn't take into account the administrative costs. It doesn't take into account the cascade problems and all the rest of it. Does that come out of the Apple case that he wrote?
Yes.
Yeah, I mean, which is generally regarded as a crank decision in many ways. It's not going to last on appeal because if you recall, what came out of that was the final judgment that, hey, this is really so difficult, I'm not giving anybody any remedy because there's no expert in the world who's smart enough to satisfy me that I can figure out what's going on in this particular case. Look, I think in effect the following argument is made, and I'll try to put it again. You take what Chris said and you ask yourself, what are you going to do with this when you get it into situations? And what was noticeably missing from his presentation, because it was only 13 minutes, was, what institutional framework do you use to figure out how you're going to implement these things? And the second point is that it turns out that the key variables in this thing all point in opposite directions simultaneously. So there is a holdout problem on the one hand and an expropriation problem on the other in the simplest form of this. And then there's the allocation of joint cost problem that you have in these settings. Well, my own view about this is if you have enough trouble doing this in the public utility context, where they did it pretty well, by the way, Brooks Scale and a bunch of other cases that did that. When you get into this area, the last thing you want to do is to have either the Department of Justice or the FTC do it. Let me put it to you in the following way. As far as I can see, antitrust is a two-point system. There's horizontal cartels and there are vertical kinds of arrangements. The rate of return of controlling cartels is essentially unambiguous. I can't think of a powerful theory that would say, hey, these are great. You could think of specific justifications for cooperation. You get into this vertical world, and it turns out it's so complicated that there is no clear path which will tell you where you want to go or why it is that you want to go there. So as an enforcement mechanism, the thought that you would take out revenues which give you very high rates of return from dealing with the horizontal stuff and go into this winter wonderland where, in fact, I believe the expected value of the projects is negative seems to me to be a terrible institutional restraint. Now, I realize that coincidence has it you happen to have some association with the Federal Trade, but I think a Federal Trade Commission, but I do think, in effect, that this is a classic set of situations in which, if you don't understand full institutional context, you get this stuff to be very wrong. And if you look at other contractual settings, nobody uses this. And there's a reason, because it doesn't work.
So I'm going to open it up for questions, but first I want to ask the other panel members whether they have responses to Richard's views.
Yeah, so there was a lot there. I think that it's tough to get it just right. I think the difficulty that we're faced with is that the ex-ante approach and the ex-post approach, neither one of them gets them exactly right. So I think, in theory, I think ex-ante is right. You don't want to give the patentee the benefit from having the patent incorporated into the standard. That's not something that the patentee should get. On the other hand, when you're trying to figure out ex-ante, it's really difficult to figure out all the patents involved, the marginal contribution of each one, so I think that's hard. Maybe one possibility is ex-post. In the Innovatio case, there was a top-down approach. Maybe it's possible here because the standard was the same thing as the product. So in that case, you can work backwards and say the standard is the product, and then you take the percentage of profits that can be expected, and then you figure out the number of standard essential patents, how important they were. In that case, the judge said these are pretty important patents, and so the literature said it was 84% of the value, and you come out to a figure like 10 cents a chip. In certain cases, maybe ex-post gets it right. In other cases, maybe ex-ante gets it right. But I agree with Richard that there are a lot of complications here. A big picture point here is that I don't know exactly what Richard's arguing against. I don't have the FTC report in front of me, but the big picture here is we should focus on the standards organization and let them have the first chance to deal with this issue. So the standards organization is made up of players from all sides of the continuum, from the licensor to the licensee to the vertically integrated. And so if they take a rule, if they say that, for example, as Etsy did in 1994 and said you can't get an injunction, and the next year they got rid of that rule, maybe that's something that we should take. If now you look at standards organizations that are considering arbitration rules, maybe that's a way to help solve some of these issues. I think that's helpful as well. So I think the issue is not that the FTC is going to come in from on high and in every one of these cases say, here is the value that you can offer, and it's a really small value and we're going to drive you out of the market, but rather what happens when parties do enter into a dispute. And I agree, maybe an injunction be on the table to make sure that efficient breach doesn't take place as much, but when there is a problem, what can you do? And so I think that's where we're stuck between the rock of ex ante and the hard place of ex post, and maybe the alternative or the solution is try to reduce the number of these cases in which the Judge Robart has to issue 207-page opinions to get to the bottom of these issues.
By the way, one other point is that even in these cases, it's a really difficult question to figure out whether you take into account the soundness of the patent in figuring out the FRAND obligation. And in the, I guess it was in the Motorola case, they ignored that, right? They said, we're treating this as a perfectly valid patent. I'm not sure that's wrong, and I'm not sure that it's right. My guess is it's probably more right than wrong, but I would like to know from people who do patent standards as to whether or not when they incorporate, they make an independent determination of validity before they put this thing into the standard, or whether they don't. And the second point, which follows up on what you said, there's nothing which says that different industries with different constellations, different numbers of players, different patents, all ought to be using the same regime. It may be some form of arbitration. I doubt very much, with all respect to Mark, that it's going to be single number arbitration that would ever be used. It works in some cases, may not work in other cases. Let 1,000 flowers bloom, because unless you have a really strong prior, this is not the case where you want extrinsic situations to stop an industry, which at this point does not seem to be in terminal distress. As I'd like to say, the FRAND process works better than the Obamacare website, so I know which one I want to fix first.
Well, what's interesting to me is I think that Michael's endorsement of the standard setting organization is a good one. As Monica pointed out, they're on both sides of standards. They're both licensing, using them. It's actually a pretty good venue. What's striking to me is, and it's a very complex valuation problem, because the value of the patent, in some sense, depends on what other technologies are in the standard. It's a contingent valuation problem. And so actually knowing by the looking at the inputs is sort of the wrong way to do it. You have to look at the outputs and the value created by the standard and allocate that. Now, you do have joint allocation problems, but it's a very difficult one. What I would say that's surprising to me is that standard setting organizations don't specify prices for FRAND. And this is one thing we're having Jonathan in the room. He doesn't have to react. But it would be useful is one of the reasons they're deathly afraid of overhanging antitrust liability for price fixing. And that, in fact, one thing that the antitrust agencies could do, they have this wonderful way of actually doing these no-action letters that reserve the right to do something, that are very little comfort unless you really know how to read it. And if they could make clear that it's appropriate for a standard-setting organization to specify FRAND in greater detail, I think they could do tremendous service to this industry. To this
Which is basically a deregulatory move.
Yeah, there's also the threat of private litigation, which the antitrust agencies can't remove simply by...
Yeah, but they can't remove it, but there's a very common pattern in antitrust litigation where first there's a public action on which you then free ride. And so what you do is you transfer first dollar cost to the agency. It's a huge benefit to any private litigator. So if you guys neutralize yourself, you're doing the ideal public service. You're spending more money and you're giving greater value. How can you beat that?
Okay. All right, any questions?
Oh, did you have Monica?
Yes. I'm not an economist. I'm not a researcher. I haven't done any of this, so I just talk from practical experience. I think one of the concerns I have is that we're trying to come up with a solution to a hypothetical problem, and I don't see the sky falling. If you look at the cases, in fact, if you look at the Motorola Microsoft case, the court actually agreed with Motorola there in terms of valuing on incremental value. But we have to look at each case specifically. We have laws in place that can enforce our patent rights, that can look at each situation. Even the Google case and all of these cases are highly fact-specific, and it doesn't mean the system's broken because we have a few large companies that are suing each other, and when you really look at the facts, it's not about standard essential patents, it's about commercial disputes. These are big companies fighting each other and duking it out in the courts, and the courts are equipped to be able to handle the situation. So I think, again, we need to look at the SSO IPR policy. Why would we have, I just don't understand the point about having SDOs, which are voluntary, okay? Companies get together, they come up with the IPR policy, they've determined what the rules of the game are going to be. So what you're doing is asking SDOs that consist of these companies who get together to come up with technological solutions to really get into the nitty-gritty of commercial negotiations, bilateral negotiations between companies. SCPs or making FRAND more specific, I think, will have a negative impact on the bilateral negotiations and will reduce the flexibility for companies to help each other. Or if you're enabling a company, I have so many examples of different types of contracts. You negotiate and you create contracts based on the specific circumstances of those two companies. But if you get very specific, you may take away some of the flexibility that those companies have. So again, I would exercise caution. The sky's not falling. In terms of the mobile space, prices are going down. Consumers are happy. There's tons of technology. There's a lot of positive things going on. So I think we need to focus on the positive and not on the few cases that seem to suggest that the sky is falling when it's not.
Okay. Audience, it is your turn.
I understand all.
If you could identify yourself.
Steve Mendelson. I'm a patent attorney here in Philadelphia. I understand the complications that are involved. As an ex-owner of a Sony Betamax, I can appreciate some of this effort, though. But my question is, are there incentives for non-participating entities to join these standards organizations? What's the experience in the real world?
You answer that.
I haven't seen a lot of the non-practicing entities. I mean, you have non-practicing entities that are not in standards, and standards is not their business model. I think we saw some analysis before. It seems like it's and I would defer to others that have done studies on it. I think you had a study on it, and I'm sorry I forgot your name, but it's not the folks that are engaged in standard setting organizations. And one of the confusions and one of the things that's happened is that some people are cross-pollinating PAEs with the issues that are coming up with in the standard setting organizations right now. And quite frankly, standard setting organizations are evolving and they're making changes, and they have made changes, and they are self-governing and they're able to address issues. So again, I would be careful to categorize PAEs with the SEP issues. But having said that, who wouldn't be a PAE? What if you have one patent that you're not practicing and somebody infringes that, and they're not an SEP? It's a one patent that's being infringed, and you assert it and you try to get compensation for someone who's infringing. Does that mean you're a PAE and you're a troll and you're no good? I mean, everybody, I think all the big companies probably have patents that they don't have a product, but they have patents in their portfolio that they can assert anytime. So my question is, how do you delineate? So again, let's step back and look at what we have and the mechanisms we have in place now to deal with the issues. And let's be very narrow in our focus in terms of how we change rules and policies, and to deal with a real issue and be careful not to be so broad that you pull in huge R&D companies, universities, others that may have. IBM has a lot of patents. Does that mean they're a troll if they assert?
Absolutely. No, I'm going to answer the question the other way. She's answering the troll question, which I think it's right. All the world's a troll whenever they sue under some of these definitions. So I don't want to do that. But the question he was asking as to whether or not a patent assertion entity should join into a standards pool. Recall what Chris said, which is essentially one of the reasons why these things work is that what comes around goes around, that people are on both sides of these things. And the more sort of flashy academic language, these guys are playing at least behind a partial veil of ignorance. The moment you start taking in a PAE, first of all, the knowledge base is way down in terms of the way this works, and secondly, the reciprocity advantages are not going to be there. So what do I suspect will happen is if you're trying to figure out who's a member, they're not going to sit at the table. But if it turns out they get themselves into problems and they say, hey, this is a standards issue, what they'll do is they'll write a dear letter, and they will say, Dear Monica, what we want you to know is that in working this thing through on the litigation end, there are these kinds of problems which may be evolved if you guys take it into account in the way in which you then choose to set your standards. So I don't think you want to treat this as simply being dichotomous, either you're in or you're out. I think what you probably are going to do is to be out of the governance structure but in on the information cycle. If you want to get in there, my guess is it's not going to be a huge volume of business, but I wouldn't treat it as an empty set.
So I think we have time for one more question. I saw Mark Lemley's hand up earlier. Okay.
Well, he'll get back at us later.
Okay.
And if there's more than one, you can take a couple. We started a little late.
All right.
The only thing I wanted to sort of observe was that
Mike.
Microphone.
Only thing I wanted to observe was the interesting dynamic on the panel in which all of the lawyers said, oh, let the standard setting organizations handle it, and the standard setting expert said, oh, no, standard setting organizations don't want to handle it, let the courts handle it.
Who said that?
Monica.
That's not what I said.
Okay, well then maybe I misunderstood, right? That I thought I understood you to say we don't want more specification of FRAND in the standard setting organization. That's not what that's going to mess up the standard setting organization. But perhaps I misunderstood.
No, go ahead, you say what you said, then I'll say how I understood.
No, I said that SDO members are the ones that come up with the IPR policies, and they're self-governing. If there's an issue between the parties with respect to the contracts they enter into outside of the standards organization, the courts have the ability to enforce patents or to deal with the disputes between those parties.
I guess my
Look, I do not think
my concern is that FRAND not be interpreted as meaning nothing whatsoever, and there are folks who seem to take the view that life goes on under a FRAND obligation just as it did before a FRAND obligation. There are folks on the other side who seem to think FRAND means I can get away without paying anything for as long as I want. And somebody, it seems to me, needs to be in a position to resolve these questions. If it's not going to be the standard setting organization, if it's not going to be the courts, it's probably going to end up being the Federal Trade Commission.
And as I said before, Mark, it's a contract. Okay, you make a contract to the SDO, and so that's a contract dispute, and the courts can resolve that dispute.
But you don't want them to articulate the same. I think what Monica's saying is what I'm saying is what me worry is a very powerful situation. This is messy, and I generally like simple rules, but this is complex problems with no dominant solution, so I like them less. And what we're saying is, well, you see a little bit of court involvement, but not very much, and mainly on contracts. The standard organizations seem to be able to resolve 99.9% of their disputes internally. If that's the way it is, leave well enough alone, because if you're going to spend all your time focused on that 0.01% and try to fix that, you're going to mess up everything else. I mean, my old colleague, my late and great Walter Blum, always used to say, when you're dealing with complex institutions, 95% correct is perfection. And that's where we are.
And I think one other way to think about it is the various stages at which FRAND could be determined. So think of three places. One is ex ante, where the standards organization says here is what the FRAND rate actually is. A second is later in the standards process, where you have an arbitration procedure in the standards organization. And the third is when you get to the court. So I think what the standards organizations are doing, and I think the ex ante letter was the Vita case a few years ago where the DOJ said, fine, you can determine the maximum royalty in advance, but as it turns out, they don't actually do it because the organization doesn't have an appetite for doing it. Maybe you're not setting a particular rate up front for all the reasons that are obvious that they're not going to choose a rate up front, but you could have the standards organization selecting an arbitration process by which you get all the benefits of standards organizations getting involved before you get to the court. And so maybe that's a more efficient way of dealing with it than Judge Robart writing a 207-page opinion, which is a lot less efficient than having the standards organization doing it.
Actually, I have a question for Monica on this set of issues, and that is why do you think it is that SSOs are so reluctant to include clear price terms in FRAND contracts. And is it because of fear of antitrust liability, or is it simply because nobody really wants to negotiate that ex ante in the absence of knowledge about how the market's going to develop?
Well, thank you for that question, and others may want to chime in on that. But from a practical perspective, you don't even know if a patent is going to be essential to a standard up front. So when you say ex ante, it's kind of like the engineers are in there, and you don't know when the standard or when it's going to be determined whether that's even essential. So I don't even know how you do that practically, and you really don't determine essentiality until the courts look at it. SDOs don't do that, and in a number of SDO policies it says we do not make an essentiality determination. So I don't know practically how you could do that, number one. Number two, again, we got to go back to practicalities. Parties know who the patent owners are. They've been working on these issues forever. They look around the table. People are making disclosures. They know who to go to, and they can have ex ante negotiations, bilateral negotiations, before the standard is set. And so they can know. And a lot of times they really want a portfolio license. So to be able to say, well, we're going to establish a rate for a patent that we don't even know is going to be included in the standard is in practicality not a reality.
There are other serious reasons, I think, that you don't want to do this. One is, of course, as Chris said, price discrimination is an essential part of the patent universe. You start setting a price schedule, essentially what you do is you take that option off the table in a large number of cases. Well, how is the price discrimination to be determined? Well, a lot of it depends on the composition of the buyers. There's stacking issues, which could be very important, figuring out what the base is, and also it turns out that the value of a set of standards may change over time. It may go up, it may go down in some way, and there's no reason to introduce that price rigidity at that particular point. And so it may be the more efficient way to do it is to have these guys concentrate on the technical issues so they get the coordination problems later, and then put the pricing situations in the hands of different people, and you also get the benefit of specialization. It may well be that the guys who are good at designing engineering are lousy at negotiating contracts, and you do this stuff. But, I mean, let me put it this way. The fundamental point here, John, is you see this stuff, you look at the profusion of successes. The basic argument is point out a defect before you correct it, rather than doing what I think the FTC has done and saying, we've spoken to a bunch of people who've never done this, and we now know what the right rule is, and I think that rule is demonstrably wrong, even though I'm not sure what the right rule is.
Christopher, do we have time for one more question? Okay. All right.
Yeah, I think there's also a practical point that folks haven't focused on yet, which is, and I don't know a lot of these standard cases in the litigation context, what I've learned is that the folks at the standards meetings are engineers.
Yeah, that's what I said.
And they're debating the technology and trying to decide what is the best technical solution to go into the ultimate standard. These are not people who negotiate licenses or have any experience in this process. So we have different people with standards.
Yeah, it's a specialization point.
But then secondly, the real world practical answer is these are not in the real world unilateral one-path licenses. I mean, these are all big companies that these SSOs. In the end of the day, they usually cross-license each other on everything, and they don't worry about what's great for this patent. It is the rare case when you're out there unilaterally licensing one patent.
Yeah. It's like real estate restrictive covenants. You get yourself a common plan, you put all sorts of restrictions on the various homeowners, and it turns out there's no price associated with any of the covenants that are put into the entire package, because it's all taken out in the fundamental notion of the price when you sell the unit with the baggage, and by moving on the one dimension, you save the transactions costs on all the specifics.
And John, I think you're absolutely right. If you go to a standard setting organization, you want to clean out a room of engineers, start talking about money. They're deathly afraid of it, and they're even more afraid of law. And at the risk of being too much of a shill for my own program, and that's why we're creating a joint law engineering program here at Penn.
On that note. All right. Thank you all.